Beautiful. Well, thank you so much, everyone, for coming. We're absolutely thrilled to be here today. Before I start, I would like to pass on to my wonderful colleague, Noongar woman and our project manager for our Hey Sis project, Charmaine Mannix, for an acknowledgement of country.
Hi everybody, welcome today. I would like to begin by acknowledging the traditional owners of the land on which we meet today, the Wongal people of the Eora Nation, and pay my respects to the elders, past, present and emerging. I hope you have a lovely day.
Thanks so much, Charmaine. Before we get started, we do want to note that we will today be hearing about people's lived experience of sexual, domestic and family violence. When we hear those, it's very normal reaction to be impacted by some of the things we're hearing. And we just remind you to take care of yourself. Feel free to turn your screen off at any time, take a step away from the computer, do what you need to do to take care of yourself and return if and when that you feel comfortable to do so. There are support services available 24/7 and right now through 1-800 full stop and the details will be in the chat box. We will be encouraging Q&A if we get time at the end, and we would request that any questions to people with lived experience in the room be directed as to the content and what they think needs to be done and not about their personal experiences. People talking about personal experience or being the mouthpiece for people who are talking from lived experience will be sharing what they feel comfortable to share. So without further ado, I'd like to kick off and look, just essentially we know that over the past couple of years we have seen a substantial commitment right across the political spectrum, right across the community to end violence against women and their children. And we have seen a huge focus on how the family law system can better operate to actually be part of that solution. We've seen the parliamentary inquiry into a better family law system. We know that was a few years back now, actually, to support and protect those affected by family violence. The Australian Law Reform Commission's inquiry into family law system, the Joint Select Committee on Australia's family law system, and then most recently the inquiry into family, domestic and sexual violence. There has been a huge amount of recommendations. We have all recognised that such violence and abuse is no longer a private issue. It is a public issue and that we all have a role to play. Today, we're going to look at the way in which the family law system operates in the context of family violence. And to do this, we want to hear about some of the experiences of people who have been through that system in the context of family violence. And then we want to hear from government, from the Federal Circuit and Family Court of Australia, and experts about some of the changes that have been recommended and are indeed starting to be implemented, which is incredibly exciting. So without further ado, I'd like to pass on we've got a full range of speakers. We have very short time available because we wanted to hear the breadth and all of those different perspectives. So I'm going to introduce each panelist as and when they're going to speak with you. The first person that I'm going to introduce is Jane Matz. So Jane Matz is a law student and a graduate of Our Watch's initiated Voices for Change project with Domestic Violence New South Wales. Jane believes she has only just started as an expert by experience in her own goal to drive reforms for domestic, family and sexual violence survivors. She has continued her change for focused advocacy by founding the Sisters in Law project, designed to challenge the status quo and drive legal reforms to support the safety of women and children nationally. Her focus at the moment is on creating safer processes in the family court by framing risk for stakeholders, empowering women with education and supporting for those who are forced to self-represent with her legally guided advocacy program. Jane, thank you for joining us, and we look forward to hearing from you of some of the real life stories that you're dealing with on the ground.
What an amazing mouthful, Hayley. Thank you so much for a wonderful introduction. And I'm really lucky to be here, and I'm very grateful to be sharing the stories of the women that I work with. As Hayley mentioned, I'm part of the Sisters-in-Law project. I'm the founder, but there's a group of us that would like to see some significant reform around the management of family violence within the family law context. And I guess one of the things that we've realised is that lived experience intersects really well with research to either validate or say, well, look, here's some gaps that you possibly haven't considered. So I guess my goal today with you is to share some of the stories that have been properly de-identified in relation to Section 121 of the Family Law Act, because we don't have a Brittany Higgins in this space, and we don't have a voice for children to come forward because of the constraints of our legal processes. It'd be nice to get some of the issues out there, because I think we are silenced, and we need to look at that going forward, because the voices of children in particular, and in particular the ones that age out of this system, we would benefit from some of their input into changing the system to make it better for women and children. One thing that I'd like to also just mention, there's maybe a trauma, as Hayley said, that some of the materials that I'm talking about, there's just some specific child sex abuse discussion here. So I just like to make you very aware. So I'm actually going to tell the stories in the first person as the mums have given it to me. So this is the story. I don't know whether you've got the PowerPoint slides there, Hayley. No. Okay, it's all right. I'll keep going. So this is what's really important in this space is to look at these particular stories. So this particular story is a story of Zara. Throughout my pregnancy, the level of violence and control in my relationship was escalated exponentially. I was physically assaulted on numerous occasions whilst heavily pregnant. And upon return from hospital, things went from bad to worse. And after 3 weeks, I told my partner that it was best that I left. He instead went away for a week and returned to our home, picked up our daughter from the arms of my friend who was holding her, and took the child into the waiting car, driving away unrestrained. The police refused to help. Unable to access money and denied legal aid, it took 10 days to issue a recovery order, and after my breastfed newborn child returned to my care, there was difficulties. He faced zero consequences, and I was forced to hand her over at the next access visit the very next day. On that first access visit, he breached the temporary protection order that was in place by physically assaulting me. Despite physical injuries, the police refused to breach him. And around this time, I discovered a printed copy of his criminal history that I had known nothing about. I discovered that he had a litany of prior convictions from serious drug, assault, weapons, and domestic violence. In one instance, he tried to drown the mother of his eldest children in a toilet. This discovery terrified me and continued, and my terror continued. I had court-enforced orders 3 times a week, 6 handovers, 6 opportunities for him to abuse me, and he did. At our child's birthday, I was then forced to allow the commencement of overnight time at quite a young age. Shortly after this occurred, my baby began to display sexualized behaviours. An assessment by an expert in child sex assault deemed that she was being exposed to sexual activity and/or pornography. The father commenced legal proceedings against me, stating a case of alienation. The father's time was increased. At the age of 4, my daughter returned home from an Easter long weekend and was visibly distressed. Later that evening, she disclosed to me that she'd been sexually assaulted by a relative on 3 occasions. Fearing the worst, and after the last court proceedings, I panicked and attempted to handle the situation myself. I could not afford a lawyer nor legal advice and have never been eligible for legal aid, despite only ever working part-time as a single mum, and I had no family support. The father seized the opportunity to go straight back to court, and after an unsuccessful mediation where he demanded 50-50, he then threatened to punch me when I did not agree with mediation in front of the mediator. I had limited legal representation due to financial constraints, but later we attended upon a family report writer, and for the purposes of an F11 report, as it was then. The report writer kept me waiting for nearly 2 hours past my scheduled time. And while she continued to speak, whilst she continued to speak with the father for such a long time. Once I came in, she allotted me just 40 minutes and spent the majority of that time talking about how she wanted to break for lunch and she was hungry. She asked me loaded questions such as, what rules do you have? To which I answered that I didn't need a lot of rules due to my daughter being such an easygoing and well-behaved child. This was documented as a lack of parenting. I was not given an opportunity to discuss any of my concerns in the domestic violence that I had endured, and it was all minimised. And at one point, she laughed at me for discussing it. She also ignored the assessment by Child Safety that deemed my daughter at ongoing risk of harm and sexual abuse in the father's care. Later, after 7 months trial, the judge, seven months after the trial, the judge awarded the father primary custody based on the recommendations of a fundamentally flawed family report that denied the existence of the father's criminal history, the domestic violence, and lied and twisted truths. The father breached these orders within 4 days of them being made, then went on to breach them again by virtually relocating with the child to another city, many kilometres away, and changing her school, even though they had equal shared parental responsibility. My daughter's academics and mental health declined rapidly. She began making worrying statements about killing herself and wanting to die. I was able to bring a contravention application to the court. Initially, advice by lawyers said that this would be unsuccessful, so don't bother. I was successful in my application. However, within the face of all the evidence, the judge declined to vary the order to prevent further harm to the daughter. And despite the father referring to me as just the birth mother on the stand, despite the judge uttering the words, "How wrong was I?" from the original decision-making, the father was given yet another opportunity and no changes were made. My experience has been one of multiple failures by multiple arms of the system. And in the case of the police, my then 4-year-old child was interviewed without my consent or knowledge in the presence of the father. She was again interviewed by Child Safety without my knowledge and in the presence of the father. And in both cases, about an incident that had happened in his home. In both cases, she was told not to say anything. I later went on to find that Child Safety did in fact make an assessment that the child was at ongoing risk of harm and sexual abuse in the care of the father. I was never alerted to this, and despite the family report writer and the judge having access to this in the subpoenaed material, not once was it ever taken into consideration. The family report writer made a report full of inaccuracies and blatant lies. The family report writer spent in excess of 4 hours with the father and 40 minutes with me. The judge acknowledged a number of times the family violence perpetrated against me by the father, however, was in his words, "I choose not to give it weight." How can these people ignore a clear history and pattern of behaviour? How can these systems have a disclosure to a third party of child sex assault and assessment by Child Safety acknowledging the risk? And what has happened in this matter and to this little girl is that nothing has happened. What do I want to change? There needs to be significant reform culturally and systemically within the family court. The rights of a child to safety above and beyond the rights of parents. For women to be heard and believed. I'd like to see legislation in place that prevents family court proceedings being brought where there are issues of child sex abuse substantiated and Child Safety has issued a risk notification. I'd like to see better access to competent and willing legal aid lawyers for women who are good respondents in family court matters. It is unfair that a child can be removed due to a lack of financial resources and for the court hearings to be heard evenly. It is an imperative that family report writers, in my opinion, have a master's qualification in clinical psychology training, as well as family violence and trauma. It is also imperative that judges are provided with proper training around family violence and the trauma and impacts on children. that's one scenario.
Thanks so much, Jane. Just you might want to make a couple of final comments, but we probably don't have time for all the other case studies that you have right now, just to make sure that we can hear from everyone. But we are hoping to hear from you at the end. Are you comfortable with that?
Yeah, sure.
Okay, thank you. Is there any final comments that you wanted to make before we kick off and start hearing about some of the changes?
The other matter that I wanted to mention was one where there is substantiation of child sex abuse, where the mother did everything that was required by state child protection at a state level. And then when it came to family court, there was she just had the mental health problems, the adversarial system working against her to actually put the information to the court to make the right decision. And it makes me wonder whether an adversarial system in these particular situations are the right forum to actually be presenting child sex abuse where there is risk of significant harm. They actually said to her as well that the reason why you're doing this is for family court matters, and the history of the matter, it happened, the issues of risk happened well before family court matters initiated. And it makes me wonder, maybe the solution needs to be, if there are risks of significant harm and issues around child protection already noted before family court proceedings are commenced, that there needs to be a stage gate, before family court can commence proceedings, some form of welfare check that is where the states are saying that it's safe for to progress to some form of contact with the father under family law guidelines.
It's interesting, Jane, that you talk about, again, like the public-private, around private litigation when there is a public safety issue at hand. And that's something that we hear time and time again around, if we have a protection order in place at a state or territory level and there's systems in place to protect people, should that be a matter that is litigated in a sort of a more of a private way? So I think that's it's very important to hear from these experiences. And of course, that's one experience. There are many, and there are also really positive experiences as well. But we're here to talk about making sure that we have a consistent approach and that we can rely upon the system for safety. There have been there's been an amazing amount of work and research in this space, huge numbers of wonderful recommendations, and in fact commitment and some changes that we are seeing at the light of the end of the tunnel as well. And I'd really like to thank you so much, Jane, for bringing this to us and for actually instigating this whole forum. We're so very grateful of the work that you do day in, day out, supporting people who are impacted by violence, accessing the system. I'd like to now move on to the wonderful, who have we got next, people? We have the after Jane, we actually have a video from Senator Cash, the Minister, the Attorney General. Do we have that ready to play?
Yeah, we're good to
Wonderful. Thank you so much, Ash.
Good morning. I sincerely acknowledge Rape and Domestic Violence Services Australia for hosting this important event as part of the 16 Days of Activism against gender-based violence. The Morrison government has a strong family law agenda, and we're committed to making ongoing improvements to the family law system to ensure that families can resolve matters safely, fairly, and quickly. We've implemented a number of new initiatives to be complemented by further action in response to recent inquiries. The Federal Circuit and Family Court of Australia commenced on the 1st of September 2021 and is a remarkable milestone for the Australian legal system. The court is now the largest court in Australia and reflects the government's commitment to reducing barriers that everyday Australians experience when navigating the justice system. The new court provides a simpler, faster and less expensive case management approach across a variety of important areas of law, including family law, migration law, and general federal law, while maintaining a focus on the safety and experience of court users. There are a number of noteworthy reforms, including the creation of a single point of entry to the family courts with a consistent, harmonised set of family law rules, processes and procedures, as well as a more efficient appeals process. These reforms will make a significant difference to ordinary Australians facing challenging periods in their lives. Another element of the court new structure is the adoption of a case management model designed to reduce costs, delay, and emotional stress. The streamlined model will significantly shorten the time families spend in litigation. It also increases access to alternative dispute resolution. The government provided an additional $60.8 million in the 2021 budget to support these important changes. They will make a significant difference to the court system. The additional resourcing has also enabled the court to create a national contravention list to help address long-standing concerns with the enforceability of family law orders. Where contravention applications previously took many months to be heard, they will now receive an initial hearing within 14 days of filing. I'm also pleased that as the Attorney-General, I have stewarded 25 appointments of highly experienced and eminently qualified individuals to the court, including a number of eminent women. 14 of the 25 appointments to the court during my tenure as Attorney-General have been female. The creation of the new court structure also complements a number of other positive reforms and innovations. The government has allocated $13.5 million to pilot the innovative Lighthouse project to improve the identification and management of family safety risks in family law proceedings. The Lighthouse project has been operating in 3 family law court registries since January 2020. It involves the court systematically identifying and managing safety risks through the application of bespoke risk screening and case management processes. Matters screened with the highest level of family violence risk are assigned to the Evett list, a specialised pathway for management by a judge-led multidisciplinary team. To date, more than 1,000 at-risk parties have received tailored support from family counsellors, and more than 500 matters have been placed on the Evett list. The government is also committed to ensuring best practice responses to family violence, including amongst the members of the judiciary. Since 2015, the government invested over $1 million in ensuring our judges have the necessary skills for responding to family violence cases. This includes working with the states and territories to co-fund a family violence training program for federal, state and territory judicial officers. The government also co-funds the National Domestic and Family Violence Benchbook, a publicly available resource to improve judicial officers' understanding of family violence. The government recognises the importance of ensuring that women experiencing or at risk of family violence receive timely and comprehensive legal support. That is why the government has expanded frontline legal support services for vulnerable women, including $129 million in dedicated funding for legal assistance services for women, over $101 million for domestic violence units and health justice partnerships that provide wraparound support to women, almost $134 million for family advocacy and support services, which provide duty lawyer and social support services to women and families with matters before the family courts, and $43.9 million for specialist workplace and discrimination lawyers to assist people experiencing workplace sexual harassment in response to the Respect at Work report. Through these significant funding measures, we're responding in a meaningful way to meet the demand for legal help from women and their families. In developing reforms, the government greatly values the perspectives and insights of those with a lived experience of the family law system. Your participation in public inquiries, consultation processes and discussions is essential to achieving the best possible outcomes for separating families and children. Thank you again for the opportunity to address you today, and I wish you all the very best for your forum.
Thank you so much, Ash, and we do appreciate that the Attorney General was not able to join us today, but we do appreciate the time and effort that she's taken in addressing the forum today. It is now my great pleasure to introduce the Commissioner of the Australia's National Children's Commissioner, Anne Hollands. Anne is formerly the Director of the Australian Institute of Family Studies. We're lucky enough to have Rachel joining us from ACE today. And for 23 years, Anne was Chief Executive of government and non-government organisations focused on research, policy and practice in child and family wellbeing. As a psychologist, Anne has worked extensively in frontline practice, including child protection, domestic and family violence, mental health, child and family counselling, parenting education, family law counselling, and community development. Anne has 2 small grandchildren, and I think it's fair to say that the rights and experiences of children are now front and centre with Anne at the helm. So thank you so much for joining us, Anne, and we really welcome your thoughts and reflections on the experience of children in the family law system in the context of family violence.
Thanks so much, Hayley, and what a lovely thing for you to say there. So I feel so welcome. Thank you. I'd like to just acknowledge that I'm joining you from the unceded lands of the Camaragal people of the Eora Nations here in the northern parts of Sydney, and I pay my respects to their elders, past, present and emerging, and of course the elders of the lands where you're joining from. I'm really delighted to be invited to say a few words this morning, especially as I'm one of the many people who with lived experience of both the family law system and of domestic and family violence. So I have a very personal interest in this issue. In a fragmented landscape of what we would describe as silo systems across the country, the family law system is a bit of a standout because it is the system that probably most people, numerically more people, will have some dealings with, and but also because so much of the work of the family law system is about the complex needs of children and their families, especially where there is domestic and family violence and sexual abuse. And because of that fact, the family court, because of the fact that the family court is at the federal jurisdiction and the child protection and other systems like domestic violence responses, mental health, drug and alcohol, etc., they're all at the state and territory level, except in WA, we've long known that children are falling through the gaps with serious and lifelong consequences. Others will say more about that this morning, and I did want to also acknowledge the stories that Jane has shared with us already. I mean, just absolutely shocking and heartbreaking. Thank you so much, Jane, for putting us through that. But, you know, like, I just think we absolutely have to hear those stories. There is no doubt that it actually makes the whole issue different if we hear from those people directly, as you've amplified their voices in this way. But I'd just like to say just a few things about why I think we need to listen to children in all of these systems in a more coordinated and systematic way. So we need to listen to children because they have something to say that's important and often very different to what adults say, often quite surprising, actually, and because mostly children's views and insights are ignored. By not listening to children, we can't assess the situation and respond from a whole of family perspective. It's just not possible. The evidence is clear, of course, that experiencing problems like domestic and family violence are connected to a variety of lifelong negative consequences for children, both immediate and later in life, things like mental ill health and problems with social and emotional and cognitive development. And pretty much these are the basics for life. And of course, we know that relationships in the family are disrupted. And I need to just reinforce that this is not just sad or unfortunate. Of course, you know, family breakdown is sad and separation is unfortunate, but relationships are everything to children. The quality and availability of their most important family relationships will determine whether or not children thrive. Children need more than just a safe house. Children need the love and nurturing of caring adults who are capable and are attuned to their needs every day. They need the stability of these enduring relationships in order to grow and develop well. Article 12 of the United Nations Convention on the Rights of the Child basically says children should have a say on decisions affecting their lives. And unfortunately, research has shown that children are often not heard by the professionals whose job it is to listen and be accountable for what children tell them. And the wonderful Dr. Rachel Carson, she should be a professor. Dr. Rachel Carson will tell us in a minute about some groundbreaking research done by APES on what kids said, and she'll tell you about how they feel that their perspectives are frequently ignored and they can feel betrayed, for example, by independent children's lawyers and family report writers, as we've just heard. But there's also generally a low level of accountability to children and young people. For example, in the need to go back and explain how their views and experiences have been used and have been applied in the processes of deciding their futures. And this, I've come to understand, is really part of what I would describe as a cultural invisibility of children. This is the idea that children should be protected by being kept out of these things which are considered to be adult concerns. That by speaking with children and listening to them, we're actually placing them at further risk. That's I guess the long-standing idea that has informed the way we work. But we're now beginning to understand, as was stated by the Royal Commission into Institutional Responses to Child Sexual Abuse, that children who are silenced are never protected. This is the opposite of what we thought is true. Not only is it a human right for children to have a say about decisions affecting their lives, it's also their best protection. How this is done is, of course, really important. And I really support the calls for ongoing training to be mandatory for all professionals who are in the front line of working with children and their families. And this includes lawyers and judges. I also think we have a kind of unconscious bias towards adults and away from children, towards believing what adults say and not believing children, towards listening to adults and not listening to what children say. There's no time this morning to really delve into these sorts of issues in depth, but I really wanted to point out that this unconscious bias away from hearing children plays out at that individual level of when they're in front of the independent children's lawyer or the family report writer or whoever it is, but it also plays out at the broader policy and systems levels where we see that children are not a national policy priority in this country and that their unique needs are often overlooked. So I'd just like to conclude now, and I'm really looking forward to having the chat later, but I think what we've heard already, particularly from Jane, is that it really reinforces that while what's gone on in the media cycle this week, I mean, you know, it's really important that we've had exposed what goes on in a workplace like Parliament House. There's no doubt that's important, but it's the stories of this much larger volume of women and their children affected by violence right across the country. It's these voices that we're not hearing, and that we, especially the children, I guess that's what I'm here to say, that really should be heard. And I do have a belief that if we somehow find a way of amplifying the voices of real women and real children right across the country, then that may have some chance of cutting through. But frankly, at the moment, we're not we're not causing enough political pain for the decision makers for them to take notice. Thank you very much.
Thank you so very much, Anne, and quite agree. And the protections, we know in states and territories across the country, there are protections around privacy and around for children where there is domestic and family violence. And we've been able to craft laws that, it varies from state to state and territory, but that we're able to kind of get that balance right, where people are protected, but also have some agency, and importantly, don't feel silent. So, but thank you so much for highlighting that from the children's perspective, such a critical perspective. And I believe that Rachel is going to kind of continue on from there with some of the really important research from the Australian Institute of Family Studies. So I'm going to introduce Rachel now. Rachel Carson, Dr. Rachel Carson, is a social legal researcher with expertise in family law and qualitative research about family law disputes. Rachel is a senior research fellow at the Institute and is currently acting executive manager of the Family Law, Family Violence and Elder Abuse Research Team. After practicing as a family lawyer, Rachel worked as a researcher in family law at Melbourne University Law School and was awarded a Melbourne Research Scholarship to undertake her PhD in this field of research at the University of Melbourne. I have been relying upon Rachel's research for a really long time, and really appreciate the incredible leading work that you do in this space, Rachel. Thank you so much for joining us. We'd love to hear a little bit about some of the work that you've been doing at AFES. Really trying to highlight the experiences of people experiencing violence through that system, but with a particular focus on children. Thank you.
Lovely. Good morning, everyone, and thank you, Hayley, for that lovely introduction and for inviting me to join the discussion today. And thank you, Anne, for that promotion. I'll let your successor know. If my slides are available, it'd be lovely if we could have them up now, but if they're not available, that's no problem. Before I begin, I'd like to acknowledge the Wiradjuri people of the Kulin Nation, on whose land I'm presenting from today, and pay my respects to their elders past, present and emerging. Today I'm going to very briefly highlight, if we could pass over to the next slide, if that's possible. And to the next one after that, thank you. Today I'm going to be highlighting some findings from two research projects, in fact, that we're working on at the moment at AFES. One's still currently underway at present. It's the Compliance with and Enforcement of Family Law Parenting Orders project. And that project's examining factors that affect compliance with parenting orders, the drivers of non-compliance, including family violence and safety concerns, characteristics of litigants involved in contravention matters, the operation of the contravention regime under the Family Law Act, and whether punitive elements of the regime are actually deterring non-compliance or inhibiting safety concerns from being raised. There are actually 4 components to this research, and if we could pass to the next slide, there's a court file analysis where we're collecting and analysing data from court files involving contravention matters. There's a survey of professionals who work with separated parents and interviews with judicial officers. We also have a survey of parents and carers and a desktop review of contravention regimes in 3 international jurisdictions for comparative purposes. And if we could move to the next slide, there are actually 2 preliminary findings that I wanted to talk about today because they're relevant to our discussion. And the first is that 85% of professionals participating in our survey of professionals indicated that clients who were seeking advice from them about contraventions had complied with orders even though they were concerned about the safety of their child. And if we may move to the next slide, the second finding that I wanted to highlight was that most professionals, also reflecting on these clients who were seeking advice about contraventions, indicated that they had orders that did not always cater for children's changing needs and circumstances. If we move to the next slide, we'll see that the surveys and interviews suggest that factors are discouraging clients from taking action in relation to non-compliance, and they include the costs that are associated with the legal proceedings, a reluctance to engage with that court process again, the complexity of the proceedings, and an uncertainty about the outcome of the proceedings. If we move to the next slide, you'll see some preliminary findings of a more general basis. And there's a tension that we've identified between the function of the contravention regime, that is, that parenting orders are made in the exercise of the best interest jurisdiction, but then the contravention regime is focused on upholding the authority of the court. There are key issues in compliance problems, including family violence and safety and refusal of children and young people to comply, that a majority of professionals surveyed consider the regime to be ineffective. And these findings suggest that punitive responses may impede the safe and effective operation of parenting orders to a greater extent than discouraging non-compliance. I would note, as Michaelia Cash has indicated in the discussion so far, that there, since the commencement of this project, there has been the commencement of the National Contravention List, which does seek to ameliorate some of these issues that we've been identifying. We may have an opportunity to speak more about that later. If we can move to the next slide, please. Some of you will be aware of the second project that I'm going to talk about today, and that was the one that Anne was alluding to, and that is the Children and Young People in Separated Families study. And key findings from the interviews with children and young people in this project included that most children and young people indicated that they wanted a family law system where professionals were listening to them more effectively, to their views and their experiences. That children and young people needed safe and effective options for participation, including in cases involving safety concerns. That participating children and young people sought proactive professionals who acted protectively. And that most children and young people sought open communication, and they wanted, as Anne said, to be kept informed of that decision-making process, its progress, and then the outcomes that were being made as a result of that. And children and young people also described the importance of having that flexibility to have a say and for arrangements to change over time to reflect their needs. And I'm just going to pass to the next slide to leave you with some quotes from some of the participants that were of particular note. And our publication from this project is available to download for free on our website, and it contains many very impactful quotes of this nature that really do provide you with an insight from a child's perspective of what it's like to engage in the family law system. And I'll just shoot to the next slide to acknowledge, most importantly, the participants in both of our research projects, and particularly the parents and children and young people who participated in our Children and Young People in Separated Families study. And I'll thank you so that we can move to the next speaker.
Thank you so much. And I'm actually going to ask you to flick back, Ash, to the previous slide. Oh, no, I would have loved to have, and I know that our time is short, to actually hear those quotes from young people. We can still do that. Would you mind reading those out, Rachel?
Of course. So Ryder was talking about the fact that from his perspective, everyone thought that he was pretty young. My opinion didn't really matter, or something. Talia, who was also in the 12 to 14 year age bracket, said that the professionals didn't listen and they interrupted everything that I had to say and was trying to force me to go with my dad. Tatiana, who was in this age bracket as well, said that the family law system services should make themselves visible with the kids and not so much behind the scenes. And that last quote, that was a theme that kept recurring through a number of the participants in varying guises. But essentially, and one of the quotes that we've used in the title of our research report is to give children a bigger voice more of the time. That was something that resonated with us as something that was key to the children and young people that we spoke with, a bigger voice more of the time.
Thank you so much, Rachel, and I appreciate you being nimble with us. Because I think, and I do hope we'll have time to come back to Jane and hear a little bit more from lived experience, because that's why we're all here. But I think that ultimately hearing from the experts in this space, hearing from those that are leading the charge for change is really, really important to wrap around that and to respond to that. But I do want to kind of hear those voices coming through. I also thought that was really a powerful point, that one of the findings of that review with children around the fact that they want an ongoing say, they want this to be reviewed, they want to be able to have their say over time. They might have said something in the family law system that they thought was best at the time, but then if they're not feeling safe after, what do? You know, is that a final matter? And they're stuck in that situation. So I think that was a really powerful thing that I heard as well. Yeah.
And particularly if orders were made when children were very young, circumstances can change. So
yeah, beautiful. Well, thank you so much, Rachel. We're going to whip on to the next. I'm going to pass the talking stick along now to the amazing Heather Douglas, who I'm going to just, yeah, here we are. Heather almost doesn't need an introduction, but she's Professor of Law at the University of Melbourne. She researches legal responses to domestic and family violence and has coordinated the National Domestic and Family Violence Bench Book since 2016. And there was a recent updating of that, which it's just wonderful, wonderful work, and we're so grateful. Her most recent book is Women, Intimate Partner Violence in the Law, published by Oxford University Press just this year. We're very, very grateful to have you joining us today, Heather, and I'm going to pass the talking stick to you now.
Thanks very much. Hello to everyone. I've put a link to the bench book in the chat just in case anyone isn't familiar with it. Basically, as Hayley said, I've been working on this since 2016. It's the National Domestic and Family Violence Bench Book isn't the go-to place for the specific procedures from each given state and territory in the family courts, but it has a wealth of information about current research and information about particular issues that seem to be arising. We try to keep it up, as Hayley said, every year in July we do an update, so we try to keep it reasonably up to date. So it is a really good resource, I think, for a whole range of issues. Over the last kind of couple of years, we've been introducing a few new things based on discussions that we've had both through my work in terms of talking to survivors about their experiences of the courts and the legal process, but also through information that is sent to us from time to time. And so we have introduced a couple of new sections to the bench book, and some of these new sections include victims as alleged perpetrators, and that's acknowledging that situation of misidentification that we are hearing so much of in recent times. And so we've put a whole lot of information in Chapter 4 in relation to victims as alleged perpetrators, so you can see research and you can link to cases that might discuss the particular issue and so on. So we really pushed hard when we produced the National Domestic and Family Violence to make it an open access resource. So yes, it's primarily written for judges so that they get the latest information and the latest case law access and so on. But it's also written for the public and for lawyers so that they can take it to the judges, because judges will really only have to deal with what's put before them. So it's to really encourage people to use the tool to actually get information from there and actually put it to the judges that they're appearing before. So there are sections, as I said, on the misidentification issue. We've also introduced a section on trauma-informed practice in Chapter 5. And I think that's really important, because I think what happens for a lot of survivors of violence, we are increasingly knowing about the kinds of effects on the way survivors of violence might, for example, give evidence. Often it won't be in a really clear linear way, and that's often an effect of trauma. So we've introduced a lot of information there so that these kind of assumptions in the legal system around credibility based on having a linear narrative, for example, we think twice before we make that assumption of lack of credibility. So a lot of the material on the bench book is to make people think about what they're doing, not take things for granted, not make assumptions. We also have actually a section on unconscious bias for judges to challenge their ideas about bias as well. So we're really trying to sort of get them to think about what they're doing and be very conscious of their work on these kinds of issues. The work that I'm doing at the moment, specifically around the bench book, is on coercive control. And as you heard from Michaelia Cash, the Commonwealth Government is supporting the bench book, and as other states and territory Attorney General's departments. But our coercive control work at the moment is very much focused on working out the best way to help to train and educate judges around understanding coercive control. The book that Hayley talked about, I interviewed 65 women for that book, and I think something like 84% of those women said the worst aspect of the violence they experienced wasn't the physical abuse, it was the emotional abuse and control, the monitoring and so on. This made them second guess themselves. Obviously that's experience of gaslighting and so on. So really to get that message out to judges and magistrates about what that looks like, how that works, and how they can respond to it in their courts, and how to avoid also, really importantly, their courts operating as a form of secondary victimisation because they're allowing this gaslighting to actually happen in their courtrooms potentially. So thinking about where people are placed in the court, who needs to be in the courtroom for the particular hearing, if there is a sort of team coming with the abusive partner, is that necessary? Is that appropriate? Can people be excluded? The subpoenas that have been issued by the abusive partner, are they actually relevant? You know, we need to not rubber stamp them as judges and magistrates. And these can all operate as factors in coercive control. Applications for adjournments, for example, are often not neutral. So really thinking about whether those adjournments are necessary. So looking at the role of judges in relation to understanding coercive control, but also understanding how their court practices can play into that process of coercive controlling behaviour. So we're speaking to the people who are being put forward by their chief magistrates and various judges in the various jurisdictions who they think are doing best practice in this space. So we're talking to them about what they think works, what they think their colleagues need, and what the best way to get that information to them is. We're also talking to them about cases they've seen or they've found useful, which clearly articulate coercive control within the judgment, and we'll be putting all of that material onto the bench book to expand on the coercive control section of the bench book. But we'll also be preparing materials for judges, including a video drawing on survivors' experience in that video, and also drawing on best practice from some judges and magistrates who will be appearing in that video. So we're really trying always to respond to the kinds of latest issues that are being seen, I guess, in the community of practice around family violence, and trying to make sure the bench book is up to date on these kinds of issues. There are sections on children and children's evidence and the importance of that. But essentially what my focus of my work has been around really trying to get lawyers and judges to understand the context of family violence so that they can figure out how to do better when they see it and actually see it in the first place. So there's the judges aspect of this piece, but also I'm working with others in various jurisdictions around Australia at the moment to also work with lawyers on improving lawyers' best practice. One of the things that I think is missed by lawyers is that their ethical responsibility is primarily to the administration of justice. It's not actually to their client. That's their secondary requirement. So really taking out education and talking to lawyers about best practice in that space as well, to make sure they're not just being mouthpieces for abusive partners, that they're actually thinking about their duty to the administration of justice as well when they're representing their clients. So that's the work that we're doing at the moment. I've put a link in the chat to the National Domestic and Family Violence Bench Book, and I'm always really happy to hear from people about things that are missing. Obviously, we have limited resources, so unfortunately our updates only happen every year in around July. And so yes, we're yet to kind of properly reflect the changes to the Family Court Lighthouse Project and so on, but that will happen in our next July rendition of the Bench Book. Some of the most important things that you might find if you're self-represented litigants or if you're lawyers working in this space is the links to the case extracts in the bench book, because that is the language of judges and lawyers. And so that will give you tools to say, well, judges do recognise this, here's an example, and take this to your lawyer or to the judge that you're appearing before. So I think I can leave it there, but look, I really hope people get value out of this resource, and if you're not, want to hear from you, and we're always happy to update it and change things to reflect what needs to be happening and best practice in the field. So thanks.
Thank you so very much, Heather. Such a critical piece of work and so educative, and also dovetailing. I think we'll hear a little bit about that. I don't know, maybe Susan will talk a little bit about the Safe and Together model, and maybe, I don't know if that's you, Lisa, around how that intersects with having that really vital resource as well. And so pleased that there's going to be such great guidance around coercive control and the pattern and dynamics of gender-based and domestic family sexual violence. So thank you so much for your work. Thanks for joining us today. I'm going to actually just skip forward on the and actually hear from Lisa now, because I know she's got to get back to court. If that's okay with everybody else, I'm going to move on to Lisa. Now, Lisa is a senior judicial registrar at the Federal Circuit and Family Court of Australia. Goodness gracious me, I've got to get that right. With extensive experience in family law, domestic violence and child protection litigation, as well as policy development. She conceptualized and is leading the Lighthouse Project, an integrated response to family violence and related risks to litigants and children, which commenced in the Federal Circuit Court in Adelaide, Brisbane and Parramatta in January 2021. I just want to do a bit of a shout out to Lisa as well, who has been listening and consulting, also has qualifications in domestic and family violence practice as well, but listening and consulting with those on the ground, those experts on the ground, women's legal services, women's safety services, and all parties, and really leading the charge of cultural change right throughout, and of course in conjunction with the Chief Justice, Will Ostragen, under his leadership. So thank you so much, Lisa. I'm going to pass on to you, and then hopefully you can get back to court.
Thanks, Hayley. So hello everyone, and look, I feel so honoured to be here in this company, and thank you, Jane, for sharing that litigant's story, and thank you to Anne, Rachel and Heather for the important work that you do. And I want to assure you that we do look very closely at that work and use it to continuously try to improve the service that we offer to our litigants and the children who navigate through our system. So today I'm going to talk very briefly about the Lighthouse Project, but before I do that, given the many comments made, I thought it might be helpful to talk about a few of the other initiatives that are changing, we hope, people's experience of the family law system. So you heard the Attorney General, Michaelia Cash, talk about that single point of entry. One of the things that gave the court the opportunity to do was change our forms. And one of the forms that was changed was the Notice of Child Abuse, Family Violence and Risk. Now, this was an important part of the Lighthouse Project as well as the merger, because the two courts, the Family Court and the Federal Circuit Court, had different rules with respect to risk. This is the document people use to say which risks they are alleging in their case, and it's important because it goes to the Child Welfare Authority. So this is part of trying to bridge that jurisdictional gap that Jane mentioned, and I think Anne also talked about that. It is a really complex system because of the complexity of federalism, but that's one of the ways that we've tried to improve the information flow between the court and the child protection systems. It's also given us the opportunity for the first time to capture some data. So when I started on the Lighthouse Project, which started off as a risk screening project in 2018, has become more comprehensive than that. I was often asked how much family violence is in the family courts, and we couldn't answer that question because we had no way of capturing that information. But now, thanks to the data we capture both from the risk screen and the notice of risk, we have a lot more information about the complexity of the cases in our system. And we know, for example, that more than 50% of our cases allege 4 or more risks. So when I talk about that, I mean family violence, child abuse, substance abuse and mental health issues. And for those of us who work in the system, that won't be a surprise, but we didn't have any concrete way of being able to show that. And I think what that tells us is that we are working with very complex, multifaceted cases, and you know, that's given us a better understanding of that. Other initiatives that have also happened around the same time are what we call the PPP 500 list. A lot of you probably know of the work that was done by Legal Aid in Victoria, which called for a better response to small property pools, because women were walking away from getting a property settlement because of the cost and complexity of litigation basically being burned off, which is part of that systems abuse that Heather talked about. That list has been very, very effective. It has an 80% early settlement rate. Very few matters actually go to a judge and settle early, with people getting fair and appropriate settlements. So that's very exciting, and we're hoping the funding for that will continue. A contravention list, which is interesting to hear Rachel's research, and I'm looking forward to reading the final report on that. But the idea of the contravention list is that many litigants told us that the orders aren't adhered to, and that there was no point in, you know, people would give up rather than try and get orders enforced. And I can tell you, in terms of the gender, this works both ways. People holding over children, all sorts of different problems created by that. So we try to now respond to them very quickly through that list. 102NA of the Family Law Act, which is the ban on cross-examination by perpetrators of violence, which has definitely changed the way final trials are managed. And then the training that we've done in conjunction with the Lighthouse Project. So that's that Safe and Together training, which has been taken by the judges, registrars and family consultants in the courts. Many of the child protection child welfare authorities are doing that training. And I think one of the many good things about that is it gives us a common language. And basically the philosophy of that training is to keep your eye on perpetrator rather than looking at the deficits of the victim, which is probably changing that focus. So as well as all those things, then I come quickly to the Lighthouse Project. So the Lighthouse Project offers litigants who file a parenting-only application at one of those 3 pilot sites the opportunity for early risk screening. That risk screening is confidential and admissible. We had the Family Law Act amended for that purpose. We deliberately did that because we wanted people to feel safe to effectively tell their story through the risk screen. The risk screen takes about 12 to 14 minutes to do. It asks simple yes, no questions. And if you screen high, you're referred to a family counsellor for referral to services. The interim evaluation found that the litigants who had done that really loved that opportunity. It made them feel safer. It gave them the opportunity to tell their story and feel heard and to get support where that was needed. So once someone does that, they're referred to a registrar to be placed on the EVIT list. There's early case management, very proactive. One of the things is the extensive use of Section 69ZW, which means that we're getting early information from the police and Child Welfare Authority to help us understand the case. That's really important because litigants often don't disclose all of their risk issues. And so information such as history related to previous DV with previous partners is often contained in that material. So it gives us a better understanding. The other thing that's happened is co-location. So that's child welfare and police officials being co-located in the court to get that early information to give us a more holistic understanding of the case. So I could talk more, but I think that probably is a very quick overview of some of the things that are happening in the court to try and improve our system. it is a complex system. There are many complexities external to the court which affect the way we operate, which relate to, you know, things like funding of contact centres, legal aid. We've talked about lawyer competence. You know, there are many complexities in this system, but I want you all to be assured that the system's continually changing and looking for ways to improve its services. So thanks so much, Hayley, for the opportunity.
Thank you so very much, Lisa, and thank you for all the work that you are doing. We are certainly seeing change. But there are, you know, as you'll hear, there are still cases. There are still cases, of course. And that's what we're hoping to build in, that consistency. And I think the expansion, you know, if the government was to support that to be a national program, would be a really wonderful step in the direction of actually obtaining more consistency in how the family court can and has the capacity to deal with matters involving family violence and abuse. So thank you again for your work. Thanks for being with us. And I'm sorry that we took a little while to get to you.
So bye-bye, everybody.
Thank you. I'm going to now move on to the wonderful Susan Hewitt-Bell. Susan Hewitt-Bell is an associate professor in the Social Work and Policy Studies program within the Sydney School of Education and Social Work at the University of Sydney. She has a strong interest in researching innovative strategies to address violence against women, children and young people, which are underpinned by principles of social justice and gender equity. Her PhD research examined the fathering practices of domestically violent men, including their perceptions of their use of violence and coercive control, its impact on women and children, and their awareness of the harm they caused their family members. You know, Susan's work in this field has been so influential, so important, yeah, look, really grateful for all you've done. And, you know, on a practical level, and I'd also just like to do a shout out to sort of acknowledge the work that you do in actually influencing and putting this research into practice as well. Susan, we'd love to hear from you around, in particular, the current research on transforming system responses to supporting non-offending parents and their children.
Oh, wow. Thanks so much, Hayley, for such a lovely, warm introduction. It's really amazing to be here with such a incredible group of women, all making such a big difference in this space. I'd also like to acknowledge that I'm joining in from the unceded lands of the Gadigal people of the Eora Nation, and I'd like to pay my respects to their elders past, present, and emerging. I guess I just, over the last sort of 10 years or so, have been really involved in a lot of really exciting kind of action research projects, many of them led by Professor, just want to give her a shout out, Professor Kathy Humphreys at the University of Melbourne. They've all been really great projects in the sense that they've all been kind of, they've all been aiming at kind of simultaneously exploring what's the state of practice, but at the same time using a kind of action research-based process to actually improve and kind of build the capacity of the workforce in this area. A lot of those projects have involved working with the Safe and Together Institute, sort of David Mandel's people from the United States, kind of doing things like actually incorporating their training and coaching into the action research process so that professionals from all sorts of different areas would come together, receive training. We'd actually measure the effectiveness of that. And it's actually, I think, heralding really good results. And it's great to see that model really gaining traction across so many parts of the world, including Australia. I guess just quickly, I just thought I've done a lot of research over the past 10 years with survivors themselves, with survivors' family members, with people who use violence and coercive control, and a lot with practitioners themselves. And I guess I just thought maybe I would just try to like summarize from a high helicopter level what have been some of the sort of common themes across all of that research. A lot of it was very much encapsulated in Jane's case study to kick us off. But I guess some of the things that we see time and time again across those, doesn't matter who we're sort of speaking to, is a few things. One being this kind of really convenient tendency to uncouple men's violence and coercive control from their fathering. and to not actually really assess how oftentimes abuse towards children and young people is part of the repertoire of abuse towards the mother, to not really recognize how children don't have to actually visually or auditorially hear violence to be impacted by that, to actually think more about the full gamut of a child's experience in terms of, what is it actually like to, have a father who creates an atmosphere that's constantly terrifying and tension filled. How does that actually influence so many aspects of your life? What's it like to have to continuously maybe move or spend time in a women's refuge and have to leave friends behind and start new schools? All of those things oftentimes don't make it to, they're not given the extent that they should when child protection workers, for example, are actually writing about the impact of domestic violence in files. I guess the second thing is that, there's a lot of underdevelopment in a lot of areas. And one would be in terms of the understanding of men's fathering and the impact of their attitudes and behaviors on children. And there's this kind of tied in with that sense, there's a sense of feeling that tied in with what I said earlier about children's experiences being narrowly reduced to being physically present. There's also this kind of tendency to put women's mothering, absolutely scrutinize it under the microscope, actually really look at everything that she's, ever done and everything that she's ever sort of felt, and to not actually go to the same extent in terms of trying to actually understand and map out and look at what has the fathering experience been like. I guess I think it's quite interesting that we hear about, it seems like despite goodwill and innovative practice and interesting things that happen, this area is so hard to shift. And I guess part of my research is really around exploring what is it about the kind of gender-based social attitudes that we have that actually kind of make it really difficult to change things. So in terms of what has been discussed about unconscious bias that Heather mentioned, it's really interesting to think about what's the unconscious bias that influences assessments, the double standards and the different benchmarks that are used to actually measure what's good mothering versus what's good fathering. The tendency within the system to say that women fail to protect, but at the same time to kind of not really shine a light on where it should be shone, in my mind, on who's actually perpetrating the violence and coercive control and what's the impact and how can they change that. I guess just quickly, the other thing that we've really found through a recent project called the Stacey Project, we developed some guidelines in that project, which I can put into the chat room, that I think are really useful. We're really looking at that perspective of the intersections of substance misuse, mental health issues, and domestic violence, and how that's another area that's undeveloped in practice. There's a kind of tendency to not actually connect the dots on and to centralize how domestic violence might actually be the thing that is driving a woman's mental distress, and her using substances needs to be not decontextualized. It needs to be seen within that context. So a lot of kind of areas, including trying to kind of build people's understanding of, as Heather said, tactics of coercive control, specifically things like actually seeing substance abuse coercion and mental health coercion, reproductive coercion, litigation coercion, actually mapping those things, having the language to actually speak about those things. And lastly, I will say in my short time, getting much better at actually, in addition to mapping the perpetrator's patterns of coercive control and violence, at the same time actually mapping all the myriad forms of resistance and strength and protective things that women do on a daily basis to be able to protect their kids and not be completely overwhelmed by the difficult circumstances that they're parenting in. That really needs to have equal footing in case files, in child protection files. So decision makers, legal actors can actually make decisions that don't blame women and that actually see all the efforts that they're making. So that's probably it for me. Thank you so much for inviting me here today.
Thank you so much, and thank you for your incredible work in this space. I think you hit the nail on the head. When we actually put the focus on the person who's choosing to use these behaviours, we see a very different picture, and there's a very different focus. So thank you very much. I'm going to move on to our final speaker before I hopefully hear back from the wonderful Jane. Christine Robinson is joining us now. She's a Bundjalung woman and coordinator of Ringabaya Aboriginal Women's Legal Centre here in New South Wales, working in areas of sexual assault and domestic and family violence for over 30 years. Having worked at Elsie's Women's Refuge way back when, Christine has a passion for providing services for women and children who have experienced domestic and family violence. With lived experience of family violence herself, Christine's advocacy is centred around self-determination and ensuring Aboriginal women get a voice in creating change within their communities and within the broader community. Christine has a Bachelor of Arts in Adult Education, Community Management. She's a current member of the New South Wales Domestic Violence Death Review Team and sits on the New South Wales Domestic and Family Violence and Sexual Assault Council. She's also my boss, a member of the board of Full Stop Australia. Welcome, Christine. Really appreciate you being here. Really keen to hear from you around the experience that you, day in, day out, you're working with Aboriginal and Torres Strait Islander women who are experiencing family violence and coming into contact with the family law system. Really keen to hear your thoughts and reflections.
Yeah, thank you, Hayley, for inviting me, and I'm really privileged to be on the panel with such great women with a wealth of knowledge and experience. In saying that, before I do start, I'd like to acknowledge the Gadigal people of the Eora Nation, which is the land I speak on today, and pay my respects to the elders, both past and present. I know we're really behind schedule, so I'm not really going to go into a long talk about what I was going to talk about, but I do think a lot of the previous speakers have actually touched on a lot of the issues that I think were really important around trauma, trauma lenses, cultural lenses, training within the judicial system, also in particular with solicitors and lawyers acting at an early stage with women coming through the process. I really just wanted to, I suppose the thing for me is looking at the gaps, and those gaps are Aboriginal women that fall in those areas of where they're not eligible for legal aid, and because they may work or they may have some money. So I do think that there needs to be more provision out there, provision or support around that, trying to be able to actually give Aboriginal women in those kind of situations more opportunity to access free or heavily subsidised legal support. The other thing I just wanted to focus on, and I think, and like I said, everyone said a whole range of different things, and I don't want to keep repeating, but I do think one of the things that I think has been a really a good process is the Indigenous Family Law List, court list in Sydney. We sit on that roster and we attend that court, and I do think it's really supportive because we went on to it really in the early stages because I don't know if you know the history of it, but when Judge Sexton was there, Rick Welsh from the Men's Shed, he used to attend, and so he actually asked us if we wanted to be involved so that we could support any women going through the process. So that's why we had that gender balance. But in saying that, it's grown quite significantly over the time with legal aid. We have women's support services there, so we have the Men's Shed to cover the men, but we also have Relationships Australia. So I think that they're the other things that are sort of missing, is just that wraparound service provision within the court and making the process accessible for both parties, and that women have the opportunity in our situation around the gendered violence. Women have an opportunity to speak to us as well as legal people. We do some cultural plans. We've been writing cultural plans, so the emphasis on cultural plans by support workers should be given much more credit than what I think they are given. Some of the reports that are expected through the courts for some of our clients have been overwhelming, and so when women are hearing about that, if they're not eligible for the legal aid assistance, they're sort of caught in a situation where they can't progress a case because they don't have the money. So we try to look for brokerage, and we do all those kind of non-legal supports as well. So just looking at those kind of things, I think there are legal gaps, but there are also those non-legal gaps that are associated with the legal work that need to be looked at as well, how we can support better and have those holistic approaches and holistic wraparound services as well within the court system. and during, after, before, after, because once we, as a statewide service, we have to also make sure that, you know, things are happening well once the person is living in their own home, and whatever arrangements come up has been agreed upon, that we're able to support that person, but also link them into services that can continue that support. Because we know that, you know, sometimes a situation is agreed to, but then, you know, hiccups come later on. So we keep being able to give women in particular that opportunity to have mechanisms to be able to, you know, go back to people and say, this isn't working, or they're doing this. And so, you know, that coercive control, we see that before, after, during, we all know it's there. It's just that trying to be able to sort of prove it, also being able to document it, and people being able to, you know, now being able to be believed about those issues, that kind of abuse. So I'll leave it at that, because I will have to get on at 11:30. I've got my AGM today, so that's why I'm a bit stressed out. But anyway.
Thank you, Christine. We should have put you on a bit earlier, so I do apologise. And but that, yeah, really, really vital view there. And look, really, the work that you're doing day in, day out. My shout out is that, you know, services like Ringabaya need to be able to be there across the community. That needs to genuinely be able to be available to women right across the system. I know the family law, the family court, the Federal Circuit and Family Court of Australia have just gone through a process of recruiting. They used to have 1, and they're going to have 8 Aboriginal cultural liaison officers in the family court process. They're recognising the importance of the Indigenous list and wanting to build and strengthen that, and that support from those liaison officers will actually be across the whole board and still available, but we need to make sure that the services are there on the ground, like Ringabaya. But thank you so very much, Christine. Really.
Sure. Can I just say one more thing too? And I sort of mentioned this to Hayley the other day, but I actually, as a victim of domestic violence previously, went through the family law court process over 30 years ago. So I can see the improvement. I do know it's there, and I think other people that have had those experiences can actually see the growth. I still don't think we're there, but I do think with all the people that are working together, there is a really huge improvement. So I think that should be acknowledged as well.
Thanks so much, Christine. But I think also in that conversation, we talked about, you know, the kinds of examples that Jane is talking about are still happening. And that, of course, we are still seeing some of those cases. So hopefully with the changes, we can get some more consistency as well. Did you have anything else to add, Christine, before I move on to Jane? No. Okay. Thank you so very much. Jane, we don't have a lot of time for Q&A, but I'm interested to hear your thoughts and reflections, and maybe some of the other stories, because I know you have permission from the women themselves to share those. If you could share just a little bit more of that, and then just sum us up before we head off for the day.
Well, I actually would like to say thank you to everyone for their pieces of information, because I think what happens is that where there's an intersection between lived experience and the work that you do, then we have a fuller response. You know, from Christine's perspective, that's a classic example. I guess I've been working with a mum who's 30 years out of family law, and she also says there's some improvement, but we still have a long way to go. And one of the, I guess, the big things for me is that I see with women who come to me is that when they need to self-represent, there's not enough information for them, and they're stuck in situations, you know, where they don't know where to go, or if they go somewhere, it's 30 minutes here, it's an hour there. Heather, I've referred many people to your bench book so they can get an understanding, but I would love to see, you know, a learning program for self-represented litigants and how to use your bench book. That would be fantastic to understand. And in fact, I would like to see the court create its own academy so that we can actually tap into the information, you know, as people working in the industry, as self-represented litigants, as lawyers, because the information as it stands on that website at the moment, it's actually really hard to access. Previously in the old website, I was able to walk women through some of that core information. It was really easy to find. Now it's much harder. I guess one of the big things that I'm concerned about Magellan. I see consistent problems with the Magellan and the way that it's executed. The way that I see in the bad cases, of course, Hayley, in the bad cases where risk assessments aren't being put before the court. These little gaps, I think, lived experience can start building what Louise was talking about. How with these stages of improvement, and I would like to see. There's 23 in our group, so some of the work of the women that is part of our group come to the family court and talk about some of these issues, that we can start working on these little levers to keep refining what we're doing. If we keep moving forward, we'll get there. It's just that process of talking, communicating, testing, evaluating, and it's fantastic that you've been able to put this forward so people can learn and start putting their ideas forward. So really grateful for you, and I think that it'd be really important to answer some questions with such little time left.
Wonderful. Thanks so much, Jane. We do have some questions here, and some of them are kind of also a little bit more commentary. I might combine a couple of them are about coercive control. How easy is it for parents to show coercive control without any single incidence of significant enough risk on their own? And that's one question. I'll combine it with this one. There is currently no protection under family violence orders or protection orders against emotional, economic systems abuse, including abuse via lawyers, protracted legal proceedings, vindictive court threats and proceedings, and a lack of financial disclosure forcing court proceedings. And of course, we know that protection order provisions, they actually vary from state to state, but in this person's jurisdiction there isn't that protection. Lawyers and barristers also profit from this and do not act emphatically or protectively. What new law reform will take place to properly protect survivors and children from this deliberate financial and systems abuse / annihilation? So I guess we don't know what new law reform is going to take place, but perhaps your thoughts and reflections on that. Does anyone want to take that question or respond? Kind of looking at you, Heather.
Yeah, sure. I mean, I think that the behind the scenes on all of this is a problem with legal aid. I just think it's totally underfunded, which is really problematic. And that's really the only set of lawyers who potentially aren't privately employed and kind of trying to make a living and get as much money as they can from the cases. So I do think there's a perverse incentive to string things out for lawyers. And that's why I think the sort of ethical issues need to be put on the table, and lawyers need to understand that. And there might be questions, or we might be able to raise complaints around ethical misconduct to really change the culture in the way lawyers behave in that context. But I also think it's about court processes, and I think some courts are doing this better than others, that are having process meeting, managing the process through the courts as well, which may or may not need both parties to be there, so that they can have judicial registrars looking at what's going on and say, no, this isn't necessary. We can settle this, or that change won't be able to be made anyway, so no, you can't get into court. So much better management at the court level about applications and so on, I think, is really important as well to deal with that systems abuse. Others might have other things to add. I mean, I think we could talk about that for an hour.
We could, and in fact, we could listen to any one of you for several hours. I do appreciate that. I guess the other thing, Christine.
I just want to say one thing before I do jump off. Just in relation to legal aid and more not having the resources, community legal centres are across nationally as well, and I do think there needs to be further investment in community legal centres, because at least community legal centres aren't means and assets tested. There is an element of that within the sector, but at the end of the day, and I do think with Aboriginal specific ones like our centre, we some of our women prefer not to go through legal aid. Just because of the fact that it's, they're concerned about docs, they're concerned about government agencies, they're concerned about not that cultural sort of response that they want. So I think, I think it's great that legal aid does need more resources, and they need to look at their criteria, their eligibility criteria, but also investing more money into community legal centres as well, that are able to do that kind of work, or give them the capacity and resources to be able to do more of that kind of work. So we'll jump off now in case anyone wants to respond to me about that, but Thank you.
Thank you
Bye,
so
everyone.
much. Thank you. Look, there are many other comments and questions. A shout out to Anne Hollands for all the work that you're doing in your space. There were also questions around the cross-examination scheme and the fact that the lawyers that are doing that work need to be adequately remunerated to ensure that that can be effective in that space. And then also a question about whether it's appropriate for private lawyers to be involved in parenting procedures, etc. So much focus on that. We're going to have to go because we're out of time. Is there any final reflections that anybody would like to make before we head off for the rest of the day? No. Look, thank you so much for all joining us. We so appreciate your time, your expertise, your generosity. We really, these hopefully is the start of the conversation, and we'd have some more. We want to hear more from people with lived experience in a safe and supported way, and that will help us make sure that we are doing our job to reform the system that we have so much responsibility to reform. Thank you everybody for joining us today, and have a wonderful rest of the day.
Thank you, Hayley.
Thank you.
Thanks.
Thank you.